county tallying center to the constituency and the county tallying centers, and finally to the national tallying center. That at the constituency tallying center, the final results of Member of Parliament for the constituency and also Member of County Assembly were declared, in quotes, were declared. However, the results of each presidential, gubernatorial, senatorial and woman representative candidates in that constituency were only announced for the reason that they were provisional and subject to confirmation. Thereafter, the results for the governor, senator, woman representative and president were taken to the constituency returning officer, to the county returning officer, who declared the winner for the seat of governor, senator and woman representative, but only announced the presidential result as received in the county before being brought to Nairobi. He concluded his presentation saying as follows: ultimately, all the 290 returning officers from each constituency came to Nairobi with the presidential results which they had announced at their constituency. The 47 county returning officers also brought their results from each county. These results were published online on the Commission's website. Even as the commissioners were reading the results as given to them by the officers were seated in the auditorium. End quotes. Being of the view that the procedure enumerated above was not only cumbersome but also susceptible to serious risks of manipulation, the committee made this recommendation at paragraph 489 of the report. Quote, that the Elections Act be amended to provide for the electronic transmission of the tabulated results of an election for the president from a polling station to the constituency tallying center and to the national tallying center, end quotes. Following that and other recommendations, the Act was extensively amended by the Election Laws Amendment Act number 36 of 13th September 2016. For our purposes, to Section 39 was introduced subsection 1C, which specifically provides for the transmission of presidential results. It reads, quote, for purposes of a presidential election, the Commission shall A. electronically transmit in the prescribed form the tabulated results of an election for the president from a polling station to the constituency tallying center and to the national tallying center. B. Tally and verify the results received at the national tallying center. And C. Publish the polling result forms on an online public portal maintained by the Commission, end quotes. Pursuant to the constitutional principles of transparency, impartiality, neutrality, efficiency, accuracy, and accountability under the present legal regime, in a presidential election, the votes cast at each polling station shall be counted, tabulated, and the outcome of that tabulation announced without undue delay by the presiding officer. The results announced at each polling station shall be transmitted to the constituency returning officer, who in turn will openly and accurately collate the results from the various polling stations in that constituency, and then promptly announce the outcome of the collation. From the constituency tallying center, the returning officer will electronically transmit the results directly to the national tallying center. The dispute is on what should happen at the national tallying center, while the appellant and the fourth respondent insist that by the provisions of the Constitution, the Act, and the regulations, the appellant is authorized to verify the results and to confirm them. The first, second, and third respondents, as well as the fifth and sixth respondents, for their part, have maintained that the results declared or announced at the polling stations are final, and no person, entity, or entity can purport to have power to verify or confirm or vary them. From our own reading of all the provisions under review, the authorities relied on in this appeal, and bearing in mind the history that we have set out in detail in this judgment, we are convinced that the amendments to the Act were intended to cure the mischief identified by the then chairperson of the appellant and other stakeholders. That mischief was the spectacle of all the 290 returning officers from each constituency and 47 county returning officers trooping to Nairobi by whatever means of transport, carrying in hard copy the presidential results which they had announced at their respective constituency tallying centers. The other fear was that some returning officers would in the process tamper with the announced results. One of the factors in the electoral system reform that was underscored in 2016 and 2017 amendments to the Elections Act was the use of information technology to guarantee the accuracy and integrity of the results of elections. Section 44 was introduced in the 2016 amendments to provide inter alia that the appellant shall, and we quote, establish an integrated electronic electoral system that enables biometric voter registration, electronic voter identification, and electronic transmission of results. 3. Ensure that technology in use under subsection 1 is simple, accurate, verifiable, secure, accountable, and transparent. 5. In consultation with relevant agencies, institutions, and stakeholders, including political parties, make regulations for the implementation of this section, and in particular, regulations. In 2017, in 2017, Section 44A was inserted after Section 44 to provide that, and we quote, notwithstanding the provisions of Section 39 and Section 44, the Commission shall put in place a complementary mechanism for identification of voters and transmission of election results that is simple, accurate, verifiable, secure, accountable, and transparent, to ensure that the Commission complies with the provisions of Article 38 of the Constitution, end quotes. Pursuant to Section 44(5), aforesaid, the Elections Technology Regulations 2017 were promulgated to provide for, among other things, information security, data availability, accuracy, integrity, confidentiality, and the retention of the voting materials for 3 years following the elections. They also provide for the establishment of the Elections Technology Advisory Committee, composed of members and staff of the appellant, registrar of political parties, representatives of majority and minority parties in Parliament, political parties liaison committee, and information communication technology professional bodies. The mandate of the committee include advising the appellant on adoption and implementation of election technology policies. It has the power to engage experts and consultants. We are satisfied that with this elaborate system, the electronic transmission of the already tabulated results from the polling station contained in a prescribed form is a critical way of safeguarding the accuracy of the outcome of elections, and do not see how the appellant or any of its officers can vary or even purport to verify those results, particularly when it is clear that by Article 86D, Section 2 of the Act and Regulation 93(1), all election materials, including ballot boxes, ballot papers, counterfoils, information technology equipment for voting, seals, and other materials, are to be retained in safe custody by the returning officers for a period of 3 years after the results of the elections have been declared, unless required in court proceedings. Under Section 13 of the Election Offences Act, it is a criminal offence punishable on conviction by a fine not exceeding 500,000 shillings or to imprisonment for a term not exceeding 5 years, or both, to interfere with election material by destroying, cancelling, or mutilating the material. The importance of safekeeping of the counterfoils of ballot papers were emphasized in this court's decision in Timami Isa Abdallah versus Swaleh Salim Swaleh. The information contained in Form 34, which has since been replaced following the promulgation of the Election General Amendments Regulations 2017, is the primary information that is itself arrived at after an elaborate process at 2 levels of the electoral system to safeguard the integrity of the outcome before it is submitted to the National Tallying Center. Regulations 37 all the way to 90 enumerate the process of counting of votes, declaration, and transmission of results. Once the presiding officer closes the polling station at the end of voting, he is required, in the presence of the candidates or agents, to open each ballot box and empty its contents onto a counting table or other facility provided for that purpose. Cause to be counted the votes received by each candidate by announcing the name of the candidate in whose favor the vote was cast. Display to the candidate or agent and observers the ballot paper sufficiently for them to ascertain the vote, and put the ballot paper at the place on the counting table or other facility provided for this purpose, designated for the candidate in whose favor it was cast. The total number of votes cast in favor of each candidate is then recorded in tallying sheet in Form 33. At this stage, any candidate or agent may dispute the inclusion in the count of a ballot paper or object to the rejection of a ballot paper. During the exercise, all the ballot papers that do not bear the security features determined by the appellant or which are marked against the names of more than one candidate, or on which anything is written or so marked as to be uncertain for whom the vote has been cast, will be marked with the word rejected and not counted. If an objection is raised to the rejection, the presiding officer shall add the words rejection objected to. The presiding officer will eventually take stock of the number of ballot papers issued to him by the appellant before the commencement of voting, the number of ballot papers issued to voters, the number of spoiled ballot papers, and the number of ballot papers remaining unused. In the presence of the candidates or the agents, the presiding officer must seal in separate tamper-proof envelopes the spoiled ballot papers, if any, the marked copy register, and the counterfoils of the used ballot papers. The candidates or the agents who may wish to do so are permitted to affix their seals to the envelope. Thereafter, the presiding officer shall, as soon as practicable, deliver the ballot boxes and the tamper-proof sealed envelopes to the returning officers, who shall take full charge of them for safe custody from that stage on. Authorized agents of a political party or a candidate are permitted to attend at the venue of vote counting within the polling station. A person nominated as a deputy to the candidate, where applicable, police officers not on duty, observers and representatives of the media duly approved or accredited by the appellant may also be present during vote counting. The presiding officer, the candidates or agents are required to sign the declaration in respect of the presidential election in Form 34. Each political party, candidate or their agent are supplied with a copy of the declaration before the results are communicated to the returning officer. Any candidate or agent, if present when the counting is completed, may require the presiding officer to have the vote rechecked or unrecounted, or the presiding officer may, on his or her own initiative, have the votes recounted at most twice, until the candidates and the agents present at the completion of the counting have been given a reasonable opportunity to exercise the right for a recount. No step can be taken on the completion of a count or recount of votes. A copy of the results is affixed at the entrance of the polling station. We bear in mind that presidential election, where two or more candidates are nominated, are held in each constituency, and the foregoing process is undertaken at the constituency, the details of which are recorded at the end of the exercise in Form 34. It is inconceivable that those details arrived at after such an elaborate process can be viewed as provisional, temporary, or interim. The inescapable conclusion is that it is final and can only be disturbed by the election court. It is clear beyond peradventure that the polling station is the true locus for the free exercise of the voter's will. The counting of votes, as elaborately set out in the Act and the regulations, with its open, transparent, and participatory character, using the ballot as the primary material, means, as it must, that the count there is clothed with finality not to be exposed to any risk or variation or subversion. It sounds ill that a contrary argument that is an anathema and antithetical to the integrity and accuracy should fall from the appellant's mouth. By Article 86, the appellant is enjoined to ensure, C, we quote, the result from the polling stations are openly and accurately collated and promptly announced by the returning officer, end quotes. It is, in our view, fallacious and flies in the face of the clear principles and values of the Constitution to claim that the chairperson of the appellant can alone, at the National Tallying Center or wherever, purport to confirm, vary, or even verify the results arrived at through an open, transparent, and participatory process, as we have already set out. Article 133(3)(c) buttresses this argument, and it stipulates, and we quote, in a presidential election, C, after counting the votes in the polling station, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. Our interpretation of this article is that the appellant, which is represented at all the polling stations, constituency and county tallying centers, can only declare the result of the presidential vote at the constituency tallying center after the process we have alluded to is complete, that is, after tallying and verification. It is equally instructive that Regulation 83(3) recognizes the finality of the results declared at the constituency as follows. It says, we quote, the decisions of the returning officer on the validity or otherwise of a ballot paper or a vote under this regulation shall be final except in an election petition, end quotes. Considerable heavy weather was made of the distinction between announced, as used in Article 86, and declare in Article 138. The argument for the appellant and the fourth respondent being that it is only the chairperson of the appellant that can declare the result of the presidential election, while the presiding and returning officers can only announce the results. While we note that the two words are not used as terms of art, and that they have indeed been used loosely in the regulations, we find guidance and are bound to adopt the reasoning of the Supreme Court in the case that we've relied on heavily in this judgment, Ali Hassan Joho. Though that case involved a dispute regarding election of a governor, the Supreme Court explained the two words and the law as follows. We quote, since the Constitution and the Elections Act do not define what amounts to a declaration of election results, the meaning of the term declaration, in our opinion, can only be inferred from the various texts in which it has been used in the Constitution, the Elections Act, and the regulations to the Elections Act. The word declared in the above article has been used to depict the finality culminating in the declaration of the winner of an election. Declaration takes place at every stage of tallying. For example, the first declaration takes place at the polling station, the second declaration at the constituency tallying center, and the third declaration at the county tallying center. Thus, the declaration of election results is the aggregate of the requirements set out in the various forms involving a plurality of officers. The finality of the set of stages of declaration is depicted in the issuance of a certificate in Form 38 to the winner of the election. This marks the end of the electoral process by affirming and declaring the election results, which could not be altered or disturbed by any authority. With due respect to Court of Appeal, the Honorable Judges did not evaluate or consider all the relevant provisions of the Constitution, the Elections Act, and the regulations thereunder. The holding by the Court of Appeal that the returning officers are only authorized to announce the election results, and that the declaration, the presiding officers are required to make relate only to the accuracy of the ballot and not to the winner of the election with respect is incomplete and incorrect. Further, the holding that the declaration in Form 35 and 36 is merely a return of or written record of the provisional election results and not a declaration of election results, in our view, arises from an inadequate consideration of all the relevant provisions of the law as well as the nature of the electoral process. This court has considered all the provisions of the law aforesaid in the earlier part of this judgment, and without hesitancy has come to the conclusion that the final declaration of election results is by the issuance of the certificate in Form 38 to the winner of the election. This certificate is issued by the returning officer. However, we note with appreciation that Justice Fred Ochieng in Suleiman Said Shabal versus Independent Electoral and Boundaries Commission and 3 others rightly held as follows, and they quote the learned judge. The learned judge said, if a declaration must be in a formal instrument, I find that the forms containing the results of the elections at every level constitute such formal instruments. When the forms 34, like the one before us, 35, 36, 37, or 38, have been duly signed by the authorized returning officer, they become instruments which cannot be challenged save through election petition. End quote of the learned judge, but we continue with a quote from the Supreme Court. And they say in paragraph 91 of that decision, quote, we are in agreement with the learned judge in his interpretation of the collective and interlocking provisions of the law relating to the entire electoral process, end quotes. We fully adopt that statement. Suffice only to reiterate that since by dint of Article 138(2), if 2 or more candidates for presidential election are nominated, then an election must be held in each constituency, whereat the returning officers play the most critical role in the overall result of a presidential election. It cannot be denied that the chairperson of the appellant has significant constitutional role under sub-article 10 of Article 138 as the authority with the ultimate mandate of making the declaration that brings to finality the presidential election process. Of course, before he makes that declaration, his role is to accurately tally all the results exactly as received from the 290 returning officers countrywide, without adding, subtracting, multiplying, or dividing any number contained in the two forms from the constituency tallying center. If any variation or confirmation is anticipated, it has to relate only to confirmation and verification that the candidate to be declared elected president has met the threshold set out under Article 138(4) by receiving more than half of all the votes cast in that election and at least 25% of the votes cast in each of more than half of the counties. The only other verification or confirmation that we can envisage, and is fact conceded by the appellant itself in paragraphs 53 to 57 of the submissions, relate to the accountability of the ballot. For instance, the number of ballot papers issued out to the constituencies, the number of ballot papers issued and correctly used by voters, the number of spoiled ballot papers, and the number of ballot papers remaining unused. Each process is verified against Form 34. Any changes to what was counted, confirmed, and verified at the constituency level before transmission is manifestly outside his powers and competence. It could well be tantamount to a serious assault on the will of the people of Kenya and an impermissible breach of the Constitution. Although the Act was amended, Section 39(2) and 3 were not changed, with the result that the appellant is empowered to announce the provisional results of an election before determining and declaring the final results. Our reading of the amendments leaves us in no doubt that the retention of Section 39(2) and 3 serves only to sow mischief and confusion after it is stipulated quite clearly in the new Section 1B as follows, quote, "The chairperson of the commission shall declare the results of the election of the president in accordance with Article 183(10) of the Constitution," end quote. It was unnecessary to retain the impugned provisions. As a matter of fact, the entire amendment to Section 39 was intended to align it with Article 81, 82, 86, 101, 136, and 138 to provide for procedure at the general elections, especially the role of the appellant to conduct the elections, determine, declare, and publish the results. By dint of Section 39(1) of the Act, the appellant is required to declare and publish the results immediately after close of polling. To facilitate the conduct of elections, the appellant is required to appoint returning officers at the constituency and county levels, whose roles are specified as follows. 1A, quote, "The Commission shall appoint constituency returning officers to be responsible for 1. Tallying, announcement, and declaration in the prescribed form of the final results from each polling station in a constituency for the election of a member of the National Assembly and member of the County Assembly. 2. Collating and announcing the results from each polling station in the constituency for the election of the President, County Governor, Senator, and County Woman Representative to the National Assembly. And 3. Submitting in the prescribed form the collated results for the election of the President to the National Tallying Center and the collated result for the election of the county governor, senator, and county woman representative to the National Assembly to the respective county returning officers. 1C, for purposes of a presidential election, the Commission shall A. electronically transmit in the prescribed form the tabulated results of an election for the president from a polling station to the constituency tallying center and to the national tallying center. And B. tally and verify the results received at the national tallying center. And C. publish the polling result form on an online public portal maintained by the Commission. And 1D provide the chairperson of the Commission shall declare the results of the election of the President in accordance with Article 138(10) of the Constitution, end quotes. We hold that going by the flow and arrangement of these provisions from the constituency returning officers at the constituency tallying center, county returning officers at the county tallying center, to the chairperson of the appellant at the national tallying center, the intention of Parliament was to delineate roles at the three levels of election determination and declaration. This was in conformity with Article 138 of the Constitution. We reproduce it to illustrate this. We quote, "If two or more candidates for president are nominated, an election shall be held in each constituency." 3. In a presidential election, B. the poll shall be taken by secret ballot on the day specified in Article 101(1) at the time, in the place and in the manner prescribed under an Act of Parliament. C. After counting the votes in the polling station, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. 4. A candidate shall be declared elected as president if the candidate receives A. more than half of all the votes cast in the election, and B. at least 25% of the votes cast in each of more than half of the counties. 7. The candidate who receives the most votes in the fresh election shall be declared elected president. And 10. Within 7 days after the presidential election, the chairperson of the Independent Electoral and Boundaries Commission shall A. declare the result of the election, and B. deliver a written notification of the result to the Chief Justice and the incumbent President, end quotes. It is evident to us from this sequence of events that the role of the chairperson of the appellant is circumscribed. Article 138 deals with events at the polling station where votes are counted, tallied, verified, and declared. We hold further that reference to the appellant in sub-article 3C is not to be construed to mean the chairperson, but rather the returning officers who are mandated after counting the votes in the polling stations to tally and verify the count and declare the result. The appellant, as opposed to its chairperson, upon receipt of prescribed forms containing tabulated results for election of president electronically submitted to it from the nearly 40,000 polling stations, is required to tally and verify the results received at the National Tallying Center without interfering with the figures and details of the outcome of the votes as received from the constituency tallying center. At the very tail end of this process, in Article 138(10), the chairperson then declares the result of the presidential election. and delivers a written notification of the result to the Chief Justice and to the incumbent President. That is how circumscribed and narrow the role of the chairperson of the appellant is. Should a dispute arise from that election, though conducted in 290 constituencies, it would be farcical to suggest, as the appellant did, that it would require an aggrieved candidate to file 290 petitions. There's no more substance in that argument than there would be in a contention that petitions should be filed against all presiding officers in their thousands. To conclude on the relationship between the appellant and its chairperson, the appellant is defined in Section 2 of the Elections Act, as well as Section 2 of the Independent Electoral and Boundaries Commission Act, to mean, quote, the Independent Electoral and Boundaries Commission established under Article 88 of the Constitution, end quotes. The appellant is declared by Article 253 to be a body corporate with a perpetual succession and a seal. It is independent, and in the performance of its functions, it is not subject to the direction or control of any person or authority. The appellant consists, in law, of the chairperson and 6 members, supported by a secretariat or a secretary. The chairperson, on the other hand, is appointed under Article 250 of the Constitution. The chairperson, therefore, cannot be and is not the appellant. It is envisaged in Article 86 that for the purpose of conducting an election, the appellant will be represented at the polling stations and constituency tallying centers by the presiding officers and the returning officers respectively, who are, as we have seen, are appointed by the appellant. They are in every respect employees of the appellant and its agents in the eyes of the law. It is as hypocritical as it is incongruous for the appellant to doubt the competency, proficiency, and honesty of its own staff as the reason for the need to verify the results to ensure they are not tampered with. The appellant has the opportunity, indeed a duty, to vet all its prospective employees to ensure they pass the integrity test before engaging them. Members and employees of the appellant are bound by a code of conduct. In any case, apart from the offences relating to voting or any other election-related offences committed by members or employees of the appellant created under the Elections Act, Section 30 of the Independent Electoral and Boundaries Commission Act makes it an offence for a member or employee of the appellant to knowingly subvert the process of free and fair elections. A person who is convicted of an offence, an election-related offence, is not eligible to hold public office for a period of 10 years following conviction. As we have indicated, there are several mechanisms that the appellant can and must deploy to eradicate malfeasance on the part of his staff and officers. We now turn our attention to the amendments to the regulations which we alluded to earlier. It will be recalled that the High Court annulled Section 39(2) and 3 of the Act and Regulation 83(2) and 87(2)(c) on the 7th of April 2017. One would have expected the concerned institutions including the appellant, to either comply with the determination of that court, or if aggrieved, to challenge it in this court, as the appellant did within 2 weeks, that was on the 24th April 2017. Instead, 14 days following the delivery of the judgment impugned in this appeal, the appellant issued a gazette notice, a gazette supplement, being Gazette Legal Notice number 72 of 21st April 2017, making drastic amendments to the Election General Regulations 2012, whose effect was clearly to render important and circumvent the declaration by the High Court of the inconsistency with the Constitution of Section 39(2) and 3 of the Act and Regulations 83(2) and 87(2)(c). For instance, Form 34, which was headed Declaration of Presidential Election Result at Polling Station, has been replaced by 2 forms, that is 34A and 34B. The former now is headed Presidential Election Results at Polling Station, and the latter Collation of Presidential Election Results at the Constituency Tallying Center. Form 34C is the one to be used in place of 37 for the final declaration of result of election of President at the National Tallying Center. The new Regulation 87 specifies that upon receipt of Form 34A from the constituency returning officers, the chairperson of the appellant shall, in quote, verify the results against Form 34A and 34B received from the constituency returning officer at the National Tallying Center, end quote. The controversial Regulation 83(2) and 87(2) were not affected by the amendment, and the object is not difficult to see. The High Court, having found those regulations to be inconsistent with the Constitution, it was in bad faith for the appellant to reenact them while pursuing this appeal. It is our firm position that the purpose for which Section 39(2) and 3 of the Act and Regulation 83(2) and 87(2)(c were promulgated or made have the effect of infringing constitutional principles of transparency, impartiality, neutrality, efficiency, accuracy, and accountability. To suggest that there is some law that empowers the chairperson of the appellant as an individual to alone correct, vary, confirm, alter, modify, or adjust the results electronically transmitted to the National Tallying Center from the constituency tallying centers is to donate an illegitimate power. Such a suggestion would introduce opaqueness and arbitrariness to the electoral process, the very mischief the Constitution seeks to remedy. We reiterate the words of the learned judges of the Supreme Court in George Mike Wanjohi that we have cited earlier, and this is what the judges said in relation to what we've just said. Quote, apart from the priority attaching to the political and constitutional scheme for the election of representatives of governance agencies, the weight of the people's franchise interest is far too substantial to permit one official or a couple of them, including the returning officer, unilaterally to undo the voter's verdict without having the matter resolved according to law by the judicial organ of state. It is manifest to this court that an error regarding the elector's final choice, if indeed there is one, raises vital issues of justice such as can only be resolved before the courts of law. Accuracy of the count is fundamental in any election. Voter turnout determines the outcome of any electoral contest. Numbers are therefore not only unimpeachable, but they are everything in an election. The lowest voting unit and the first level of declaration of presidential election results is the polling station. The declaration form containing those results is a primary document, and all other forms subsequent to it are only tallies of the original and final results recorded at the polling station. We reiterate, as we conclude, that there is no doubt from the architecture of the laws we have considered that the people of Kenya did not intend to vest or concentrate such sweeping and boundless powers in one individual, the chairperson of the appellant. The responsibility of the appellant to deliver a credible and acceptable election in accordance with the Constitution is so grave and so awesome that must approach and execute it with absolute fitly, probity, and integrity. The appellant must, in all its dealings, be truly above suspicion and command respect of the people of Kenya for whom it acts. Much depends on it. Indeed, the present and future peace of this country. Ultimately, we find no fault in the determination of the High Court to the extent that Section 32, 39(2) and 3 of the Act and Regulation 87(2)(c) provide that the results declared by the returning officer are provisional, and to the extent that Regulation 83(2) provides that the results of the returning officers are subject to confirmation by the Commission, these provisions are inconsistent with the Constitution and therefore null and void. There is no merit in this appeal, which we accordingly dismiss. And because of the public interest nature of this appeal, we make no orders as to course. Mr. Paul Mwangi, we now have our quorum sheets. We need to have our record straight of those who are before us.
Yes, sir. For the appearance, Paul Mwangi, who appears from Goa. First, second, and third respondents. We have Mr. Willis Oteno, Mr. Michel Ina, for the Attorney General report respondent, we have Mr. Charles Mutinda, Mr. Stephen.
Is Mr. Stephen Girenji? Yes.
Madam Correction, Mr. Ben Heiner appears
I thought you had all these lists because I saw you standing before we started.
I did. He came in as a proceeding operator. Madam, for the sixth respondent, I appear together with Mr. Tende Moro, to studio law, Mr. Anthony Wood, and Ms. Celestine O'Keefe. And Mr. Andrew Muchemi.
Mr. Andrew Muchemi.
For the people responded is Mr. Lempa Soyenka.
Mr. Soyenka. Have we left out anybody for our completeness of our record?
So there's Mr. Orenja Omina.
Orenja? For which party?
That is the party and fact.
Is that it?
That is it, my lord. My lord, on behalf of all the advocates appearing today, express our gratitude for the ruling today. Unless any party has any application.
No, I just need to repeat what my Dynamic colleague has declared to be expressed in the one wants to be forced. My lord, we have a big issue if it is possible, my lord, for the court to supply during the course of the day,
Yes, the second one.
My lord, the court can also provide a degree that follows from the judgment and the proceeding of this appeal to the offense in the shortest possible time.
Oh, are you done?
I'm done. You know, if that can be done by the court, my lord, as an administrative order.
On behalf of this bench, we also would like to thank our counsel who participated in this appeal regarding the application of the copy of this judgment and the decree. Yes, the judgment will be available at the end of the day through correction, but at the end of business today you should be able to get a copy, and thereafter the usual exchange of the decree and all that can take place. We thank you, and the court now adjourns.